rise to speak in support of this bill, and my remarks will be mainly regarding the donor conception register. And before I actually make some comments on why I think this is a good bill and why it should be supported, is that I'd just like to provide a bit of a timeline on the issue of donor conception in this state. And I'd like, at the outset, I'd like to thank Damien Adams, who actually provided me the information for this timeline. Damien and his group of support group have been working on this issue for many years, in fact many decades, and I think it's appropriate, given that this bill is now before us, that people fully understand the depth of emotion involved in this issue and what this bill means to a lot of people like Damien and also the support group and others who they represent. So, and I'll give a bit of a potted history, only because if I go through each entry which Damien has provided me with, I'd use up my 20 minutes quite easily, and I probably need more because it has a long history, but I think there's some parts need to be put on the record. In terms of this issue of assisted reproductive technology, it starts in 1988 with the Assisted Reproductive Treatment Act of South Australia, allowing offspring the ability to access non-identifying information. And that's where this, if you like, the journey starts for some people. In December 2000, the South Australian Council for Reproductive Technologies recommends to the Minister for Human Services that the Code of Ethical Practice be changed to reflect the now generally held consensus that donor-conceived offspring should have access to identifying information on their donors. This is December 2000, and we are now in February 2024. So it's been a long journey for a lot of people. During 2004-2005, Damien Adams begins lobbying, including correspondence with the then Health Minister on trying to get changes to the bill. And the Minister did advise that the Health Department was considering register and proposal in a not too distant future. That's back to 2004-2005. In March 2005, the Donor Conceived Support Group and Damien Adams write to the federal people, in fact the chair of the Human Rights Subcommittee, seeking clarification and support with advocacy for a national register for people who are born through donor conception. The committee basically says that their role is to educate rather than advocate, so they wouldn't be extending their role beyond that. Undeterred, Damien writes to the Health Minister at the state level, who advises that funding priorities don't allow for the register to be implemented at this time, and that's back in 2005. Again in 2005, Damien writes to the then Honourable Tony Abbott MP, Federal Minister for Health, seeking assistance from the federal government, and sadly gets the response that the Australian government is not currently planning to act at a national level. 2006, the Donor Conception Group meet with advisors to then Minister for Health, Honourable John Hill, meeting to see what his views and that of the government of the time. Sadly, the matter didn't progress that far. 2006, Damien writes to a number of MPs, including the independent member, the Honourable Bob Such, and who was actually a supporter of what they're seeking to do. In 2007, Damien writes to the Federal Attorney-General, Philip Ruddock, and the South Australian Attorney-General, seeking changes to donor conception and a register. The Donor Conception Support Group then travelled to Sydney to meet with the Federal Attorney-General to discuss the issue of a national donor conception register, because clearly a national register is the best outcome, given that people can be donated in one state or in one jurisdiction and actually conceived in others. So a national register would be best, but failing that, state-based registers are worthy as well, particularly if the state-based registers are in unison with other states. In 2009, Donor Conception Register Reproductive Clinical Practice Amendment Bill is passed and supported by the then Minister for Health, Jack Snelling. 2009, the Donor Conception Support Group of Australia travelled to Canberra for a meeting with the then Senator Trish Cosson to discuss the possibility of a federal inquiry. In 2010, Damien travels to Melbourne to present evidence before the Senate Legal and Constitutional Affairs Reference Committee. Also makes a submission to the Victoria Parliament Law Reform Committee into access by donor-conceived people. In 2011, the then Senate committee recommends that all donor-conceived people have access to knowledge of the donor and their siblings, and that if a national donor conception register is not achieved, the committee recommend that each state and territory should put their own in place, and that is what is happening now. Fast forward to 2015, Damien meets with the then Shadow Attorney General, Vicky Chapman, and I have my first meeting with the donor conceived support group and also Damien. And that's when I was briefed on the issues involved. A few months later, there was the first Australia-wide conference of donor-conceived people was held in Melbourne, which I attended and which I learnt and got a better idea of the issues involved, but also the experience of donor-conceived people and the difficulties with their lives, lacking that information about who their father is, both from a medical point of view, but also from an identity point of view as well. And that conference was very successful and also provided a great deal of momentum right across the country to actually get changes to the laws required. Fast forward to January 2017, Professor Sonia Allen's report. Professor Sonia Allen was actually commissioned by the then Minister for Health, Jack Snelling. She was a guest speaker at the conference in Melbourne, and who was highly recommended as a person to inquire into this matter. The Minister actually commissioned the inquiry, and Professor Allen's report made a whole range of recommendations to which the government then tabled the response some months later, and which indicating that a register would be created in South Australia, but also looking at the possibility of identifying information about donors. There was a number of other meetings take place, and then in late 2017, the donor support group met with the then Minister for Health, who's now the Premier, and who indicated that he was very keen to get some of the recommendations of that report put into place, and that also he would then, unfortunately, in 2018, we lost government. And since 2018, while something's happened on the key issue of the register and the key issue of providing an opportunity for donor-conceived people to get identifying information was actually put on the back burner, and nothing happened for 4 years. During the period when we were in opposition, the donor-conceived support group met with myself, now the Minister for Health, Honourable Chris Picton, who indicated that if we were to win government, we would revisit this matter with greater deal of empathy for the lives and experiences of the people who are donor-conceived. In 2019, there was some changes to a private member's bill, some changes to the legislation as a result of a private member's bill moved by the Honourable Connie Benares in another place, which my party and the Labor Party supported. Undeterred, Damien Adams and other 7 Australian donor-conceived people present we actually attended the United Nations Geneva on the 30th anniversary of the UN Convention on the Rights of the Child. And the UN Rights of the Child actually, Mr. Acting Speaker, makes it very clear that children have rights to information about their biological and also cultural history. In March 2022, just prior to the state election, the now Premier met with the donor-conceived support group and made it very clear that if we won the election at the March elections, we would support and introduce and support a bill to give effect to some of the recommendations in Professor Allen's report, and in particular enabling donor-conceived people to get to access identifying information about themselves, where it existed too. That's important to say. It's very important to also, unfortunately, because of the history of this issue, not all that information may be available, but also it's important to do that. And on the 30th of August, in terms of the timeline of 2023, the now Health Minister tabled this bill in Parliament, which was a greatly received bill by the donor-conceived community. That's a bit of a potted history of where we're at, Mr Acting Speaker, and I do that deliberately because this is not just some thought bubble by a group of people or this minister. This matter has been debated, looked into, inquired, investigated at length. In the meantime, we have a group of people in our community who just want to know who they are. It's a simple question. They just want to know who they are, and part of that is knowing where they come from. That's important. And if you need to understand that, just look at the amount of money now people do in organisations like Ancestry, Ancestry and other groups to find out what their biological origins are, because it's important to people's identity. It's also important to people's cultural understanding of who they are, but it's also important in terms of their own personal health. So we are, in reality, a product of our history, and it's important this group of people know their history. It's important. And the reality is, Mr Acting Speaker, I think the committee's moved on. The concerns raised by the opposition in this current debate, I don't think are shared by many people. I accept some people will not be happy with this decision, but overwhelmingly, my view is that the rights of the child, if they are paramount, then they are paramount. We actually make those rights paramount by law, and that's what this bill seeks to do, because the child had no say how they were conceived. The child had no say in what information is available to them or not, and the child now, in my opinion, does have a right to have that information to them. And the opposition states that they'll bring balance to this bill by changing that provision where people who are, since I think it's 2004, if I remember correctly, who, or prior to 2004 I should say, who didn't provide identifying information, that should remain secret, for a better word. Well, that doesn't provide balance to this bill, Mr Acting Speaker. I think that actually guts this bill and removes an important provision. Providing balance means you can actually enhance, you could tweak, enhance a bill. You do not enhance the intentions of this bill, the intentions of the donor-conceived support group, or the rightful aspirations of those people who are born through donor conception, their right to know who they are. In fact, we'll be going backwards in some ways, because this bill makes it very clear this is now possible, and then if we were to support the Liberal Party's, the Liberal opposition's amendment to take that away, we'd actually like be dragging the carpet underneath their feet and forcing these people to fall to the ground once again. It would be a cruel act to do to this group of people. In terms of supporting the bill a bit further, Mr Speaker, I mentioned a little earlier that Professor Sonia Anna was actually commissioned by then Minister the Honourable Jack Snelling to do a report in this matter. Highly credentialed professor, highly regarded in both health and the law, and she did undertake extensive consultation on this matter and produced a very substantive but also very thoughtful report, and provided some really practical advice on what needs to be done to address this. And so one of the key recommendations was that, subject to appropriate mechanisms, that donor-conceived people have access to identify information. The register, Mr Speaker, which I mentioned, does currently hold information on donors, the recipient parent of this donated human reproductive materials, and any person who was born as a result of donated material. The bill seeks to enable a donor conception register to function retrospectively. And I think I can understand why people would have some anguish about being retrospective. In this case, I think the bill's retrospectivity is actually justified. It is justified because it actually corrects a wrong which is imposed on a whole generation of children who are now in the main adults and who have children of their own. And that also is important because it enables these adults to actually share their history with their children and grandchildren, etc. In doing so, South Australia will not only join jurisdictions including Victoria, New South Wales and West Australia that all have donor conception registers available to donor-conceived people. South Australia will also follow Victoria in legislating the retrospective disclosure of a donor's identifying information donor prior to 2004. So in this regard, while this is new ground for South Australia, it is not new ground for Australia. So what we are doing is both practical and right. Is not some radical thought, but something which actually is worthy of support, and we'll be following Victoria. This will allow, the bill will allow donor-conceived people to access information about their donor, irrespective of when they were born. Where the information is verified, the identity of the donor will be disclosed, providing donor-conceived people the right to their genetic parentage. It is recognised that historical donors made these donations on the understanding they would remain anonymous. However, it is important to note that these amendments place no requirement on any donor to have contact with the donor-conceived offspring. And I think that's an important safeguard in the current bill as well. And that's where the balance is. The balance is in this bill already, but the bill doesn't need to be amended to remove that balance. The government has given careful consideration to legislate a retrospective donor conception register. The government has sought expert input and has undertaken extensive consultation with those that this legislation will impact, including the donor conception community, our state's fertility clinics, as well as stakeholders across Australia. This consultation has included the South Australian Donor Conception Reference Group and National Advocacy Group Donor Conceived Australia, which have supported the development of this bill and helped ensure the model proposed for South Australia is workable and allows disclosure of personal information in a safe and respectful and ethical manner. Mr. Speaker, I would just like to reaffirm that this bill, what this bill does, provides a proper process where this information is provided with the proper supports. The alternative is people just keep searching, or there's Ancestry.com and other similar things around the world where they find the information and there is no supports. There is no safety nets. This bill does provide a safety net and supports at the right time. As mentioned, the increased access and use of home DNA testing and services include Ancestry DNA also contribute to donor-conceived people being able to find out the identity of their donor. However, this approach does not provide the system support and assurances that would be present under the proposed regulatory system for South Australia. Mr. Speaker, as I mentioned a bit earlier, and I can't, it's really important as human beings, we love to get an understanding how we fit into this world. We'd like to know who we know, who our parents were, our grandparents are, our history, and how we got to be where we are today in our lives and our experiences. It's true for if you're born in Australia. It's also true for people who are born overseas and who migrate and lose contact with families. That identity is very important, and it's particularly important for the people who don't have that clear historical connection because of the lack of information. This bill makes sure, and helps to ensure, I should say, that information is available to this group of people. Mr. Speaker, in recognising the particular impacts that may be felt by the pre-2004 donors, the government will make important counselling and intermediary support services available to this group, which is really an important part of this bill. So we are, through this bill, getting the balance right. The reality is, if people, as I mentioned, if people get information from other sources, there is no support mechanisms, and actually there's more opportunities for conflict and harm and emotional harm for both the donor and also the donor-conceived child. With those comments, Mr. Speaker, I fully support this bill, and I'd like to thank the Donor Conceived Support Group for their work, and I'd also like to thank the officers in the department who I've had a number of meetings with, and also the Donor Support Group who worked cooperatively to both understand the lives of donor-conceived children and also the legislative framework. And I think this bill is the right response and has been achieved by extensive consultation and engagement of the people involved. Thank you.